Section 363 of the Bankruptcy Code allows a buyer to acquire a debtor's assets free and clear of virtually all liens, claims, and encumbrances, a process sometimes referred to as cleansing a debtor's assets in bankruptcy. Well, great, you say. I don't have to worry about doing due diligence on the debtor's liabilities. Those will all get wiped out under the sale order, right? Well, not so fast. I didn't say all, I said virtually all. There are some liabilities that you may still need to be concerned about, even in a Section 363 sale. One area you'll want to pay careful attention to is environmental liabilities. Although you can generally buy assets free and clear of monetary environmental claims, or even equitable claims for which the regulatory agency would take money, for example, where the government does the cleanup and then gets reimbursed, there are some exceptions. If you're buying real property, for example, and the real property is contaminated, you may well be walking into a circle of liability that won't be cleansed through the bankruptcy. At a minimum, you shouldn't plan to rely on the bankruptcy court's sale order to shield you, and should be looking instead at whether and how you can assert a bona fide purchaser defense under CERCLA itself. And of course, a purchaser has to comply with all environmental laws and regulations on a go-forward basis, which, depending on the state of the assets when you purchase them, could involve significant cost. Another area where purchasers have found themselves facing liability notwithstanding a free and clear order is product liability. Product liability claims that are already known at the time of the bankruptcy are pretty straightforward. As long as the debtor provides adequate notice to potential claimants, the sale of assets should be free and clear of those claims. Now, where it gets tricky is when you have tort claimants who don't know they had a claim at the time of the bankruptcy. Now, there's generally two types of future tort claimants. One, someone who was exposed to the product prior to the bankruptcy, but hasn't yet manifested symptoms or discovered that they were injured. Asbestos exposure is a classic example of that. Or two, someone who was injured after the 363 sale as a result of a defective product that was manufactured and sold by the debtor before the bankruptcy. Think of a faulty ignition switch in a car that was manufactured pre-petition, but then sold and injured someone after the 363 sale closed. As to the first category, those are probably claims within the meaning of the Bankruptcy Code. They're unmatured claims, but the event giving rise to the debtor's eventual liability has already occurred. So, given adequate notice to the future tort claimants, and that adequate notice topic is enough for a whole video in and of itself, it should be possible to buy those assets free and clear of those particular claims. However, people who fall into the second category just don't have claims at the time of the bankruptcy. No amount of notice can alert them to the fact that they should be participating in the case and asserting their rights, because they haven't yet encountered the defective product that sometime in the future is going to cause them harm. Since they don't have claims, there's nothing to take free and clear of. And when those claims do come into being, 6 months or a year or whenever from the closing of the sale, that free and clear sale order can't do anything to bar them. So does that mean that the purchaser is automatically liable? Not necessarily. Even if the claim is not barred by the bankruptcy court sale order, the tort claimant will still need to prove that the purchaser is a successor of the debtor. But the purchaser definitely faces some risk in this scenario. In summary, Section 363 is a very powerful tool for debtors and asset purchasers, but there are some liabilities that it doesn't reach, and it's important to be aware of those.